has clearly shown that the existing process of law cannot overcome systematic and ingenuous discrimination. No law that we now have on the books, and I have helped to put 3 of them there, can ensure the right to vote when local officials are determined to deny it. In such a case, our duty must be clear to all of us. The Constitution says that no person shall be kept from voting because of his race or his color. We have all sworn an oath before God to support and to defend that Constitution. We must now act in obedience to that oath.
Good to be with you, MKD. On March 15th, 1965, Democratic President Lyndon Johnson stood before a joint session of Congress and urged Congress people to pass what would become the Voting Rights Act, a law meant to protect one of the most fundamental rights guaranteed by the Constitution, the right to vote, and to do so freely without systemic, often violent suppression. It was a heady moment. Civil rights activists across the country were pushing to desegregate everything: lunch counters, classrooms, ballot boxes. And the response, especially in the South, was intimidation, violence, at times even murder. Just months before Johnson made that appeal to Congress, 3 civil rights workers, Michael Schwerner, James Chaney, and Andrew Goodman, were murdered in Mississippi, shot dead by the Ku Klux Klan, who used a bulldozer to bury and hide the bodies. Their offense? Working to register black voters. It was a shocking discovery, but yet not yet shocking enough at the time to force Americans to really look. That moment came days before Johnson gave that joint address we started with at the top, and it happened in Selma, Alabama on March 7th, 1965. Hundreds gathered on the Edmund Pettus Bridge to march from Selma to Montgomery. Among them, as you well know, a young John Lewis. They wanted voting rights. What they got was a beating. Using billy clubs, whips, and tear gas, state troopers and local deputies thrashed the crowd. Battered bodies, fractured skulls, some were temporarily blind. The images that you're watching right now were so awful. The day became known as Bloody Sunday, and it forced the country to reckon with what brought us there. 10 days later, Congress introduced the Voting Rights Act. 5 months later, President Johnson signed it into law. It has now been 60 years since then, and some argue that the part of that law that barred racially discriminatory voting laws is no longer needed. In fact, that case was just made this morning in front of the Supreme Court. Some of the justices on the bench sounded sympathetic to that argument, which leads us to ask, if the court does overturn that portion of the law, what will it functionally mean for equal rights in the voting booth? Joining us now, senior writer at Slate and co-host of the Amicus podcast, Mark Joseph Stern, historian, professor, and chair of African American Studies at Emory University, Carol Anderson, and director at the Center for Politics, editor-in-chief of the Crystal Ball, and author of Campaign of Chaos, Larry Sabato. All right, let's start with the legal part of this first. Mark, tell me what was argued in front of the Supreme Court today and where it appears the justices were likely to fall.
So lawyers argued that Louisiana violated the Constitution when it drew a second majority black district in order to comply with the Voting Rights Act. For decades, the Supreme Court has interpreted the Voting Rights Act to require these opportunity districts that have large black and brown populations so that these communities can elect the representatives of their choice. But today, lawyers argued that that is unconstitutional, that taking race into account to draw districts, even if it is designed to boost representation for minorities, even if it is designed to remedy past discrimination against minorities, that violates the Equal Protection Clause by considering race, and that the Constitution must be colorblind. And it sounded like a majority of the justices are leaning toward embracing some form of that argument, which would essentially dismantle the Voting Rights Act as we know it today.
How do you know that that's the way that they were leaning?
All 6 of the Republican-appointed justices indicated that they think that the Voting Rights Act has essentially outlived its usefulness. Justice Brett Kavanaugh continually said that there has to be a time limit on any race-conscious law and suggested that the expiration date for the VRA has arrived. Justice Barrett suggested that Congress went beyond what the Constitution requires in prohibiting these kind of racially skewed maps, and that it couldn't be squared with the Equal Protection Clause. Justice Thomas, Justice Alito, Justice Gorsuch all indicated that protecting black communities by drawing race-conscious maps that give them more representation is actually racial discrimination, that it is unconstitutional because of the mere consideration of race. And so the law, again, as we know it, must fall. Now, I don't know exactly how the justices will decide to dismantle the law. They could interpret it differently, they could strike it down, but all 6 of them seem to be leaning towards some kind of result that would radically weaken, if not altogether demolish, what we know of the Voting Rights Act today.
So